There is a hyper-technical objection called commenting on the evidence that the judge may sustain you on that for that reason, but I think that's usually pretty rare. Let's talk about impeachment evidence and substantive evidence. Everybody knows prosecution is usually not allowed to admit police reported evidence. Okay? But I may want to impeach the police officer with something that he's testified to, with what was in his report, with what was in his narrative, right? But I don't want to get the thing into evidence. I don't want the jury seeing what he wrote down. You can use that just for impeachment purposes. It doesn't have to be admissible. You can impeach the cop with it. And the other side might jump up and say, well, you know, Judge, under the completeness doctrine or something like that, they ought to be allowed to see the whole thing and try and admit it. Some judges are going to let them do that. I think the best thing to say is, Judge, if there is any completeness issue, we need to find out what that is specifically in the document that would, in fairness, rebut it. Or maybe they can take that up on direct examination. But the document doesn't need to be admitted. If it is, it needs to be redacted except for simply those parts of the document that were, in fairness, under the completeness doctrine, or should have been let in or whatever. You have to ask yourself, what purpose am I using the evidence for? Is it for impeachment? Is it more of a substantive evidence? Substantive evidence, the jury gets to take that back with them into the jury room. Impeachment evidence, they don't. So if you impeach a cop with the police report, the jury doesn't get to look at that. They don't get to take that back with them into deliberations. But anything you admit into evidence, they do get to take that back with them. My cousin Vinny, if I remember the movie right, and I've seen it 2 or 3 times now in the last month, so hopefully I did. There's a point where Vinny is cross-examining the eyewitnesses. And he did a good job in his investigation. He went and took some photographs of the window, the dirty window, the dirty rusty screen, the trees that were out there, the leaves on the trees, the bushes, everything that would obstruct this guy's view. So what he does on cross is he goes up, he does a great job, and he shows the guy all these pictures and said, you know, goes through it one at a time. Now, isn't it possible that maybe you were mistaken about seeing these 2 guys and you just saw a couple guys get into a convertible? And he said, yeah, I guess that could have happened. But what he didn't do is he didn't admit him into evidence. He failed to get him into evidence. He allowed it simply to be impeachment evidence. You want to have, if you're trying the case, you want to get that evidence in. You want to admit it into evidence so that the jury can get it back there with them during deliberations and consider it. As well as, you know, you can't really preserve your record for appeal with impeachment evidence. The appellate courts aren't going to consider that. So how would you do that? Let's talk about laying a foundation for photographs. We'll talk about this, expert qualifications, and then relevancy, hearsay, and some other miscellaneous issues that you're probably likely to run across in your practice more times than other evidence issues. Obviously, a wide variety of stuff we could talk about, and even hearsay and relevance and expert and stuff like that, you could really have whole 8-hour seminars on just in and of themselves. But photographs, it doesn't have to be you know, who you get it in with. It doesn't have to be your witness. Obviously, Vinny could have showed those photographs to the prosecution witness like he did. It doesn't have to be the photographer. Heck, the person they didn't even ever have to see the photograph before. But as long as that witness can say what the photograph represents, as long as they can say that it's a fair and accurate representation of what it represents, and let's just say it's the scene of the alleged crime, okay? Is this a fair and accurate representation of the scene? Yes, it is, okay? It will come in at that point. If you're trying to get it in for time purposes, let's say you're trying to show that this is what the scene looked like at the time of the allegation, and you want to go one step further and say, does this fairly and accurately represent the scene at the time of the allegation, or at the time of the alleged crime? Yes, it does. Okay, then it's admitted. And that's pretty much it. But I think some people think, well, it has to, you've got to prove that time. You've got to show that that's what it looked like at the time of the allegation. But you don't. Let's say your purpose, and it has to do with your purpose. Why are you admitting the photograph? Maybe you're admitting the photograph to show that, look, there's been some lighting that's been installed since the time of the crime was committed, and you think the jury ought to be notified about that so they're not confused by the prosecution's pictures and the prosecution's arguments that, if you have a lighting issue, for instance, if it's a nighttime crime and that kind of thing, and that would affect your identification. So that's photographs. Experts, we use Fry in Alabama. It's a 1923 case. It basically says that when you are dealing with an expert who will use scientific principles, a scientific test, if those principles are novel, then those principles must be generally accepted by the relevant scientific community. You contrast that with Dauber, which was a 93 case. In Alabama, we do use Dauber in federal court for everything, and also for DNA evidence. So the judge is more of a gatekeeper there than the relevant scientific community. Here in My Cousin Vinny, he should have had a Fry hearing. There should be, if you say that whatever scientific evidence or scientific test he used to determine that those tires came from this specific tire and that kind of thing. If that's a novel scientific test, you're going to want to have that hearing to try and keep it out. Because if you keep it out, you're in much better shape from a defense perspective. And who can be an expert? Can anybody be an expert? Do you have to have a PhD? No. You can be an expert. You can have expert qualifications if you are, if you possess a degree of knowledge, training, skill, or education that will, that's better than the average layperson, that will be helpful to the jury. All right, let's talk about a couple of issues in evidence. Relevance. What is relevant evidence? It's relevant if it is material, and basically that means if it matters. Because if it doesn't matter in the case, what does it have to do with anything? So if it matters in the case, it's material. And it's relevant if it has a tendency to prove or disprove, one way or the other, something that's material. And that's relevance in a nutshell. And you could have whole day-long seminars on that. Hearsay, I'll just say this. You hear a lot of times people say, well, it's not hearsay, Judge, because it's not offered for the truth. And yes, that is definitionally not hearsay. But just because you can get around the hearsay exception, don't forget that it still must have a relevant purpose. If you're not offering it for the truth, what are you offering it for? The other side has to say, they have to say what purpose they're offering it for, and that purpose has to be relevant. A lot of times, as from the defense, we'll want to get in state of mind, and that's very relevant in a case that's not a strict liability kind of case. Miscellaneous issues 104B. If you haven't or you don't know about this rule, I just suggest you look at it. It's a good rule for, a lot of times the judge says, I don't see how this is relevant, and you tell the judge, well, Judge, we're going to prove it up later. Just, give us some leeway, give us some time, and we'll get it in. You can do that. The rules allow you to do that. They allow you to do it through 104B. So just take a look at that. If the judge is teetering on their decision and they don't know which way they're going, you want to give them, say, hey, Judge, it should go to the weight of the evidence, not its admissibility. Allow the other side, look, maybe they've got some issues here, some legitimate issues. Let them cross-examine on it and allow it to go to the weight of the evidence, not its admissibility.